To order. Regular meeting of the Town of Emerald Isle Board of Adjustment. I'm now going to move to take roll. Mark Kahuna.
Here.
Scott Henson.
Here.
Mark Brenneschultz.
Here.
Eric Hevelin.
Here.
Andrew Frick.
Here.
Tim Kinch.
Here.
And Mark Wicker.
Here.
All right, we do have a quorum established. Next item on the agenda is to elect the chair and vice chair. So I'll let the board members, discuss among yourselves and go ahead. Sure.
Out of the 7, which 2 are deemed alternates?
I'm one of them.
Okay, so Mark Wicker's one. Who was our other alternate? I'd have to, it's across the street.
I think it's me.
Okay, Andrew Frick
Yeah.
and Mark Wicker.
I think so, yeah.
Sorry, I didn't have that information available.
Yeah, I think it's me because I'm on a 1-year.
Who was the other alternate? Was that?
Mark Wicker,
Okay. No, I mean, the first one.
Andrew Frick.
Andrew? Okay, thank you.
So can the alternates be chair or vice chair or, no,
It's got to be a
regular member? Okay.
Good question. And the chair, just in case anybody's not familiar with that role, if you've ever been to a town meeting where the mayor sort of presides over the meeting and opens the floor and handles the agenda, that's sort of the role of the chair. Very good. All right. See, we're all learning. But the chair is in charge of the meeting, so to speak. They run the procedures and make sure things keep moving along, the things on the agenda get addressed. When you have hearings, we have to make a ruling where applicants may be presenting to you. There may be an objection about an evidence matter or something. The chair makes the initial decision on the objection, things of that nature. The vice chair serves in the absence of the chair. So both have to be one of the 5 regular members in that regard. If there's any other questions I can.
But the chair also signs the meeting minutes and other stuff according to.
Correct, so a
right?
decision, like a final written decision of the board, you all have input, but it's officially signed by the chair, and the minutes of the meetings are prepared. In this case, I guess, Mikey Taylor will be secretary to the board, so he will handle some of that with the meeting minutes as well.
Have any of you guys that are not alternates served in that capacity before as chair?
I've never been as a chair. I'm a lawyer by trade, and was a trial attorney, but I was also an administrative hearing officer for the federal government for about 5 years. So I do have a little bit of context and experience doing this type of stuff. Serving as a hearing officer is pretty similar. I don't know. I would put my name out there if you guys want me to do that.
Okay. Anyone else?
I was on the, on the board for about 10 years, maybe 12 years, in the aughts and teens, and including chair of it for about 8 years. So it's not my intention to stay on the board forever, but I just thought it would help to, if there's some, fairly experienced people around to get started. And
Well, I would certainly recommend Eric for chair and Mark, you for vice chair.
You want to make a
I would
motion
make
then?
sure, I'd make a motion or nominate Eric for the chair position and Mark for the
Are you
vice chair.
okay with that?
Yeah,
I don't want
It'd be my pleasure.
Okay.
Anybody else?
I will second.
Okay.
So we have a motion and a second.
Motion and a second, I would just do a you can do a roll call vote. So start, I guess, with Tim. I almost said Tim. And we say yay or nay, and we'll tally those.
Yay. Yay.
Yes.
Yay.
Yes.
All right, we have, congratulations. Good job. Great job. All right.
That's great.
Well, you get a hammer, too.
Official now. Wave it loudly and proudly. Excellent, excellent.
I think you need to, you're in charge.
Oh, yeah, Eric.
Now it's my job.
It's your show. That was quick.
We are here, but it's your show.
That's right. And an interesting side note about this, so you're approving minutes from the last meeting, which was a year ago.
Yeah.
Yes.
So interestingly, and this applies to all, town boards and different things, the board is a sort of a living body that continues on, past, present, and future. So this board is the authority to approve minutes of the board, even though it was in the past. So I've got a lot of questions over the years of, I wasn't even there, can I? Yes, you can approve it. So this will be a routine thing when we adopt the agenda. We'll approve the minutes from the prior meeting, which will be circulated to you in advance to review for, make sure they were correct. Not necessarily verbatim, but correct accounting of what happened at the last meeting and the votes. So if you've reviewed these, are there any objections to them, make them known. If not, you can just do a yay or nay vote to approve the minutes that are in the agenda packet. Motion and second.
So procedurally, should I open the door, open the window, or open the floor to a motion for that?
Yes, sir.
Okay. Can I make the motion?
Yes, sir. Yes, sir. As chair, you also get to vote on everything.
A motion to approve the minutes of the meeting that occurred on February 17th, 2025.
I second the motion.
I have a question. Is there anything with that case that is still pending?
Not that I know of.
Okay,
No, sir.
thank you.
I was there a year ago. It's done.
Yeah.
Any other questions? Should we vote?
Yeah.
Start with the vice chair.
Do we,
You can do it in mass, all in favor, all opposed, or you could do a roll call, whatever works.
okay, yes, I approve.
Yes, I approve.
Yes, I approve.
Approved. Approve. Approve.
All right. Approved, motion carries. Thank you.
The next item on the list is a adoption of agenda.
So just procedurally and routinely, the agenda will come out from the planning director. And if anybody wanted to change anything about the agenda, add something to the agenda, and we'll talk about that in a little bit more detail in a minute. This will be the time to make a motion, say, I want to add something on the agenda. This is just general procedures of the board information for you. We'll tailor it to the board of adjustment and all. And that can be amended by a majority vote. So that's pretty straightforward. If there are no changes or modifications to the agenda, then there'll be a motion to adopt, second, and a vote. Pretty straightforward.
Motion to approve the agenda.
Second?
Okay. Anyone? The vote?
Aye.
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 Aye. Okay.
All right. And I'll mention my caveat about applying, changing the agenda to the Board of Adjustment. Most of the time, the things that will be in front of you for presentation to decide require notice periods about, you got to notice to the public, we're going to have a hearing about this particular issue, or to the parties to an application, they got to get so many days' notice in advance. So I don't suspect we'll be just taking things on and off the agenda very quickly. But just as a formality and procedural step, that's how that's going to work. So it may not come up much, but in advance of the meeting, if anybody had a question about something that's on the agenda or adding something to the agenda, John can point you in the right direction on that sort of stuff.
I have a question. If we have to have any of these types of hearings, will one of you two guys be present?
Yes, sir.
Awesome.
Yes, sir. Yes, sir. 100%.
So you're counsel for the town,
For the board.
for the board?
We are
for
your
you all.
lawyers.
Yes, sir.
We work for you.
So when you all have hearings, the town will, at times, if they oppose the application, they'll have representation that represents the town interest. During that time, we solely make recommendations to you all for the board itself.
Which is what we're here to talk about tonight.
Yes,
How
sir.
we do that.
We'll get there. Okay.
Yes, sir.
Yes, sir.
Thank
Great
you.
question.
Item number 6, board of training. Should we move on to that?
Absolutely. All right, well, I think we had a chance to say hello to most of you before we got started, but I'm Tim Carraway. This is my associate Clay Davis. Give you a little bit, just information, introductory stuff about us and what we're here to do tonight, and I'll turn the floor over to Clay. I'm a partner in the firm. I manage our Raleigh office. We have 3 offices in North Carolina. And I've lost count, but we are somewhere around 24 local government municipalities that we represent, boards and special projects. So we are all over the state, from pretty much the triangle east to the coast. For a brief time in 2024, I was the interim town attorney here for maybe 1 meeting. And then I've been Board of Adjustment Counsel since January last year. In the last year and a half, a lot of the town codes have changed. Members have come on and off. We've had staff changes. So John and I kind of agreed to start you off in your term on the Board of Adjustment. Let's start off with some training. That'd be the best thing to do. As we mentioned a moment ago, we are the Board of Adjustment's attorney. So we are your lawyers. We are here for you. Okay. There may be times, like Clay alluded to earlier, where the town may be involved as, you got to think of them as like a party. Okay, you're the court. There's 2 parties coming to you, and you're going to be asked to make a decision. So the town may be represented through the town attorney or perhaps some other law firm, but we are your attorneys, okay? Our goal is to get you guys familiar with the legal requirements and procedures when acting as a Board of Adjustment. Doesn't mean we always make popular decisions here at the Board of Adjustment, but good news is it's not a popularity contest. One party may be happy about the decision, one party may be unhappy about the decision. Parties have the right to appeal your decision to the Superior Court. That may happen. It's okay. I like to think of it as an attorney involved in these kind of cases, as a board member. When we do things correctly, we follow procedure so that everybody in front of you's got fair procedures, due process. We create a good record, which means we rule on evidence, objections. We make sure we have a good record, meaning what evidence do we look at when we made our decision? Those things are very important at this level because our decision gets appealed. There's no bigger compliment that we can receive is when a court upholds our decision. That means we treated folks fairly. We gave everybody fair procedure, due process. Our decision was based on evidence, and we articulated that evidence in the questions we asked, the documents we reviewed. Okay, so that's the way I look at it. If our decision never got appealed and it got upheld, that's a compliment from the court. Good job. If it gets overturned, doesn't mean you made the wrong decision. All right, so rest assured, don't worry about that. Clay here is an associate attorney with us. Like myself, he travels all over the state. The last few years, he's gotten a wealth of BOA and zoning law experience, representing boards, representing cities and towns. I think so far he's undefeated so far in these kind of things. So
I've been fortunate.
He's been good. No, he's modest, but he's very good at what he does. We're glad to have him at the firm. I'm gonna turn it over to him for the presentation, but like I said, moving forward, our goal is to get you guys comfortable with these procedures so you know what to expect. We will be at every Board of Adjustment meeting here for you guys. Okay. The decisions are yours. Yep. Okay. We're not here to give you a decision, to say, this is how you should rule. That's not what we're here for. You guys should rule. I like to think of it about when I take my kids bowling, we pull the bumpers, keep them out of the gutter. Our job is to kind of keep you in line as far as what's legally required and be mindful and respectful of that. But the decision is yours.
I might have a question.
Yes, sir.
As
Yes, sir.
alternate members, what is our role here and what, on a routine basis?
Good question, very good question. So, as long as we have the 5 regulars here, you don't get to vote, unfortunately. But we encourage you to come, please, for a couple of reasons. One, we all have different lives. We never know what's going to happen. Somebody gets sick, somebody gets an accident on the way, God forbid, things of that nature. So, if we have you here and one of the 5 is out, you will be in their seat and you'll be just like a regular member where you would vote. Being in attendance also helps learn these procedures, gets comfortable with them, gets comfortable with how we do things, that sort of thing. In the event that somebody had to resign from the board, any reason, good or bad, that's likely, you need to fill in on the board potentially for that issue as well. If you're not going to make it, and I think this would apply, and I won't speak for John, but if you're not going to make a board meeting, if you kind of know that in advance, you can communicate that to John, because we want to make sure we have enough folks here to carry on business. It takes 4 out of the 5, and not all still Clay's thunder, but you got to have at least 4 of the regular members to conduct business. So if one is absent, one of the 2 alternates can fill in, and we can help make that quorum that we provide. Answered that for you.
Thank you.
All right, yes, sir, anytime.
Awesome.
All right, Ms. Davis.
All right, good evening, everyone. As Mr. Carraway introduced me previously, my name is Clay Davis. I've had the privilege of working with Board of Adjustments in the form of Board of Adjustment attorney, advising boards. I've had the honor of representing landowners in front of boards. So I've seen both sides, and I've also had the opportunity to represent cities in advocating their position in front of Board of Adjustment. So I've been able to see this at every angle, and I'm grateful for that. I started my career here in Carteret County, practicing for a local law firm. Fell in love with a woman from Zebulon, and she said we need to move closer to family before we get married. So thankfully I ended up with Mr. Carraway's firm, and I consider myself a trial attorney. I love the courtroom, so it's hard for me to talk to you all sitting here, but I'm happy to do it. I'm used to moving around. I want to make sure you don't have to follow me around the whole room the whole time, so I will stay here. But I'm thankful to work with you all in this capacity as well, because I get excited about Board of Adjustments hearings. You all, essentially, I like to say, as one of our partners has said in the past, you all are judges, but unfortunately, you don't get robes. You all get to make legal rulings. You get to hear cases that eventually a Superior Court judge might hear. And you all get to make rulings on evidence, and you don't even have to go to law school. So that's the cool part. Sorry, Mr. Chair, you did the hard part. But
And you're the only one that gets the gavel.
he gets the best of both worlds. But that's how much I enjoy working with Board of Adjustments. So starting just from the beginning, kind of the outlook on you all, I think this vibrated. I think it went the wrong way. Perfect. So again, you all have 5 regular members. You've heard a lot about that, 2 alternates. So a quorum, you need 4 members, as Mr. Carraway alluded to. That's just so you all can conduct business. If 4 people aren't here, then you can't take action. And so that's why it's very important to have 4 regular members that can vote and take action. These are some of the duties that you all have. The appeals of administrative decisions, we'll go through those. Not all of these will apply for you all. One thing I wanted to do was just talk about some of the more common decisions we see around the state. So thankfully, you all don't have to worry about special use permits, which are the more contentious ones. But you have other things like variances, and we'll go into that. So that's some of your roles before here. And I hit back again. This time it didn't vibrate.
And just to interject just quickly, when we look at the big picture here, your Board of Commissioners for the town is the governing board.
Yes.
So they legislate ordinances and they pass the local laws, so to speak, okay? They have divested or given away some of their decision-making power to this board. And so it's different from city to city. Some cities, the governing board sits as the Board of Adjustment and everything goes to the town board, city council, town commissioners. Here, that rests with the Board of Adjustment. So the planning board is separate than the Board of Adjustment. Legally, you have to have, even if the governing board is the Board of Adjustment, you have to have a planning board.
Right.
And that's for, think about it like, public input. You're going to make a legislative change to the zoning issue or change, the zoning maps. That's your place for public review, public comment, because we want the citizens involved with that process, and that's where that input is really gathered. The Board of Adjustment, if the governing board releases some authority, has that authority to make certain decisions. So here, on the screen here are certain kinds of quasi-judicial procedures. Not all of them have been released by the Board of Commissioners to the Board of Adjustment here in Illinois. But we're going to cover the three that have in this case.
And that's a good point. With regards, because I believe you all sit as the planning board as well. No, they do not anymore. Okay, perfect.
They don't anymore? Okay.
Perfect. All right. So thankfully you all have one role. You all come here, you're the judge. You get to do, you get to make decisions while you're here, and you have to hear evidence. So perfect. You get the fun part. So these are some of your more common ones. We have variances, which you all do have authority to hear and consider the administrative decisions. So administrative decisions, the way I like to put it is, it's if a staff member, if a citizen has to approach a member of the city, town staff, and to get some type of approval, and they disagree with that approval, you all get to hear about it. So you all will hear a vast amount of permits or different types of decisions. Our most common ones are if someone wants to, let's say, develop a subdivision, and there's a disagreement about what an ordinance says, and you can ask the planning director, how do you interpret this ordinance? So you can direct me, citizen, on how to do something. Well, the planning director will have an interpretation, and then that citizen can say, I will abide by that interpretation, or I want to appeal that to the Board of Adjustment. And that's where you all come in. You all hear the administrator's decision, rule on whether or not they made the correct decision, and you have to base that on evidence. We'll get into that. But that's just an example of what an administrative appeal looks like. It's kind of a broad category that you all will get to consider. All right, so quasi-judicial standards, every board decision must be, you're going to hear these words a lot, and I apologize ahead of time. These three words, every board decision must be considered by substantial, competent, and material evidence. So what does that mean? Substantial evidence means someone reasonable would hear that evidence and say, you know what, that makes a difference in my mind. For example, someone says the sky is blue, right? And that's what they have to prove. You got to prove the sky is blue. If someone who's sitting inside all day said, yeah, I saw the sky today, it was gray. Well, they didn't see the sky. They don't know what color it was. They didn't go outside. But then you bring someone in here that says, yeah, I walked outside, I looked outside, I saw the sky was blue. That's substantial because you have someone before you that saw that evidence. That's substantial. It means something to you. It's what a reasonable jury would expect, or excuse me, what a reasonable jury would consider adequate. You all get to play both roles. You're the reasonable jury in this case. So then we move to what's competent evidence. So competent evidence, it's a term in my area of law for quasi-judicial law that gets thrown around a lot, but all it means is someone is qualified to say what they say. So if someone comes here and says to you all, I believe this use is dangerous to the community. Well, a layperson can't say that. They need to have some type of training to talk about why they think it's dangerous. They need to have some type of background that qualifies that statement. And you might hear attorneys come in here and say, objection, the witness is not competent, or the witness is not competent to make this statement. They're not being ugly. They're just saying under the legal standard, this witness is not qualified to testify about this subject. And we'll talk a little bit more about that. So now let's go into objections. I talked about attorney making a competent objection. Let's say someone comes in, they testify, I think this project is dangerous. Objection, competence. That goes to you, Mr. Chair. So at that point, you can make your own thought and say, you know what, I've heard it, objection, I think it's overruled or sustained. Or I'm happy to help, Mr. Carraway, if we're over here, legal counsel, what are your thoughts on this? I recommend X. You can take that recommendation and make your own determination. If you believe it's competent, you can overrule it, or you can sustain it. Let's say you sustain it, and that person doesn't like your ruling. Well, then what happens next is that person, the attorney who objected, can say, or the person who does not agree with your ruling, can say, I want to appeal that to the entire board. So what does that look like? Instead of it being the chair's decision, the rest of the board, just like you voted on agenda items, you all would vote on the objection. You all would discuss it openly, And then someone would say, I make a motion to affirm, agree with the chair, or I make a motion to overrule. And in that situation, you would overrule and the objection would have the opposite effect. In this case, in my example, the testimony would be permitted. So any questions about that, with the evidentiary side? Yes, sir.
Is that just a majority, or is it 4 out of 5?
Yes, sir. Great question. It is a majority to overrule the chair's ruling in that.
I'm sorry?
Yes, sir. It is a majority to overrule the
Yeah.
chair's ruling. Yes, sir.
Majority of the regular members.
Yes, sir. Thank you. All right. So now let's talk about what does a quasi-judicial decision look like? Treat it like a courtroom. That's my best advice. My best advice is staff will usually open the presentation. Is that consistent, Mr. Plan Director? You all will open if there's a quasi-judicial decision, you all will give your staff report first. Perfect. So staff will give their report, kind of an overview of what the application is talking about, what you all are going to hear today based on the ordinances. Usually it goes into the standards you all can consider. And then after staff presents, my recommendation is look at who has the burden of proof and let them go first. And so we'll go into that. But for example, a notice of violation, I believe you all still hear those for administrative appeals. So if someone comes in with a notice of violation, the burden is on the town to show you all evidence that the violation actually occurred. So in that case, I would let town present their evidence first. Let them call their witnesses, just like a courtroom. Let them call witnesses to testify. And then people who have standing, we'll go into standing more in a minute, have an opportunity to cross-examine that witness. Usually what that looks like is, if it's a notice of violation, the town will have their staff member who worked on the report that led to the violation, and then the attorney for the property owner is cross-examining that staff member, is usually what it looks like. And then at that point, this is where the tough part comes in, especially for the chair. Only members with standing are permitted to participate in the evidence. Technically, under the law, you can take evidence that you find relevant. I don't recommend you do that. I recommend you stick to the standing requirements. If someone doesn't have standing, and that's the hardest part, because you're going to have members of the public who will be very passionate about certain issues. But if they live 7 miles away, and they believe that this project could harm a property 7 miles away, it's hard pressed to have standing to present evidence there.
So,
Yes, sir.
so in the example you gave us, to have standing in that notice violation, you're talking about the person that's charged with a notice violation and/or the person that's charged?
Yes, sir.
Okay, those people have standing.
Yes, sir. They all, so the people that always have standing are the applicant, which in this case, in a notice of violation, I guess you would say the accused party, but the applicant always has standing. The town always has standing to participate. The town can always be represented. They can always cross-examine, call witnesses. That's adequate. Now let's talk about other people that, yes, sir.
Can the next door neighbor, does next door neighbor have standing?
Great question. So usually what standing is defined as is someone who, adjoining property owners, immediate vicinity, so in your neighbor example, or someone who would suffer special damages. Special damages is a very broad category. Some examples of special damages are if your property values would be affected by the decision. Again, if you're further down the road, it's hard to say your property values would be affected. But it's a case-by-case basis, and that's where we're here. We're here to help. If you have questions, what I always tell my boards is, don't be afraid to use the lawyer next to you that has to do legal research in their daily lives to say, Mr. Attorney, they've presented this evidence. What are your thoughts? And then my thought would be, well, based on North Carolina case law at this point, this person lives 8 miles down the road. They don't travel down a road based on, so let me backtrack. They live 8 miles down the road. They probably don't have an interest here. That's my understanding. There have been cases where someone's stormwater that they were receiving would be increased by the project. Some courts have found that sufficient, but it's based on the project itself, or the application, or the notice of violation, or excuse me, or the hearing that's being heard, right? So the approval, rather. Yes, sir. Did that answer your question?
Yeah,
Perfect.
thank you.
So that's with the standing side of things. I want to go back to what is competent evidence? Because again, it's a broad category, but thankfully the legislature's helped us out just a little bit. So talking about what is competent evidence, there's three things that have to have an expert. That the person who's claiming this evidence to be true must be qualified to say the very thing. So, and that is property values, how a use is going to affect a property. They need to have some type of appraisal training, I always say. They must have some type of real estate training. We can't, and that's tough because you have people next door that want to say, this is going to affect my property. If you build this close to me and you grant this variance, it's going to affect my property. That alone, our courts have, the cases have told us in our courts that generalized grievances or speculative grievances about how something will affect your property, it's not competent evidence. So we always have to have an expert for how your property will be affected by a certain project. All right, so then increase in vehicle traffic. This is another tough one. Yeah, your next door neighbor says, well, if you're going to put a commercial establishment next to my neighborhood, of course more cars are going to drive down that road. Of course it's going to increase it by 100 more cars or so. We need an expert. We need a traffic engineer that will say this will result in this many trips per day. This will result in this effect on vehicular traffic. The legislature's told us we need an expert for that. And then this is the third one, matters where an expert would likely be required. What does that mean? I always tell my boards, look for, is this a specialized area? For example, if this person comes in talking about how I believe if you build this cell phone tower next door to me and it gets icy and ice falls, it could hurt someone. My kids always go outside and that tower could drop ice on top of me. That's a case out of the Supreme Court. That's okay, because obviously someone can say that would hurt someone, right? But if you have some other type of project that can have an effect on the environment, and someone comes in and says, well, I read online, Google told me that this is how this particular use would affect the environment. We need an expert, someone with education, someone with training. We need that person to come in and testify on that person's behalf. So look for things that require education, look for things that require training. Sometimes with the area of construction, that gets tough. If you have someone that comes in, because everyone has lived in a home, they can testify to way their home was affected by something like a storm, or they could say, oh yeah, well I had a leak and it wasn't leaking before, but what was the cause of that leak? That's where your expert testimony comes in. So look for training, look for educational areas. All right, so we'll move to the next slide. Do you have anything you want to add to that? Yes, sir.
Question, maybe going back just a little bit.
Yes, sir.
When will we receive notice of an appeal and, or an application for a variance? When will we as board members, do we not see it until we reach the meeting?
Great question. So.
Or, you know, go ahead.
No, sir, you go first.
My question with that is, if we get advance notice, are we allowed to go out and look at the property before the meeting?
That is the hardest part. Yes, sir. So your ordinance, so it depends on the ordinance. I believe your ordinance does permit it but it must be disclosed. I believe site visits are permitted. I'll check back on that to be sure, but I believe I remember reading that. Most of the time I recommend on my boards not to, because you're here, because you can have certain specialized knowledge. Let's say there's a project on Smith Road. You've been there your whole life. You know what happens on Smith Road. You know that there's this many houses. You can say, you know, I lived on Smith Road, and there's 4 houses here. Maybe we don't need 2 little townhomes in the middle right here. That still might be a step too far. I always recommend my boards base it solely off the evidence presented. What's told to you, base it off that. If you know generally the location of where a project might be taking place or an application, keep that in mind. But the effect, let the evidence be what drives you there, is my recommendation. Because you have to disclose ex parte communication if you've talked to anyone about it.
fine.
And then you have to.
I would,
Sure.
say, I went out and visited the
Of course.
property and it's, and, and so forth, and then hear the argument, and
Yeah.
pro or con, I'm not,
So,
Right.
and that would be the other side of
I
things.
want to know what the general environment, what are you guys talking about?
So that's a great point, because what would happen next after you've disclosed it? The next question is, can you remain impartial? And you've just told me you can remain impartial even if you do that. So there,
And kind of to tie up a couple points here together as well is, the term is quasi-judicial hearing. What you're doing is a quasi-judicial, almost court, is what you guys are doing. You're almost a judge in court, okay? That's what makes it quasi, because you're not a court. But you are expected to do certain legal procedure things, 1, 2, 3, make sure they're all done, due process here. The grand scheme of things, we are a governing board, potentially limiting or regulating what somebody can and can't do with their property, pursuit of life, liberty, and property. So these are big fundamental constitutional issues that have digested down to the town of Emmerdale and their zoning issues, okay, zoning code. So it's quasi-judicial in nature in that certain due processes, rights attached. So piggybacking on Clay's comment about, we generally advise boards not to take an extra field trip to the site. Some of the reason for that, if it's, right here on 58 and you can't help but drive by it to go anywhere in town, that's a little different. But can you remain impartial even if you drive it past every day? But the reason for recommendation, though, is we want the decision of the board to be based on the facts that are presented by the parties. And that becomes the record. Okay, so what's in the record? If you had a conversation with a neighbor to that site who just lambasted the project and just told you how bad it was, and you think, man, I wouldn't want that if I'm next door. And you rule in such a way, or your basis for ruling in such a way can't be supported by the arguments and the evidence received by the board, then we got a problem. So that's why we have that recommendation. And that's why we say things called quasi-judicial, because you are sitting like a judiciary, like a court, without the requirement of being lawyers and judges and all that fun stuff. But attached to that are due process requirements. So that's why we have the records kept. That's why we have evidentiary objections and things of that nature.
When are we going to get the applications?
How far out do you send agendas?
So for this one, it was just last week. I try to do by Wednesday every week. I got the one last week by Thursday. But if we had something that they need to look at, as soon as advanced as I could.
Okay.
Yeah.
right, it just kind of to go back, so let's go back to my Smith Road example. I don't think there's any problem during the hearing where if you had an applicant that was on Smith Road, you lived there your whole life, and you say, I know the layout of the houses pretty well, Mr. Applicant, what are your opinions about this? That's your knowledge, living on Smith Road, asking the applicant based on that knowledge. But where you go wrong is you can't say, I've lived on Smith Road my whole life. I don't think there needs to, like I said, I don't think there needs to be 2 townhomes here just because of my knowledge alone. Courts have said that that's not competent evidence. The backgrounds we have alone.
But you would recuse yourself.
Yes, sir. That's a good point.
If,
Yes, sir.
that's in here somewhere.
Yes, sir.
Yeah.
You can't be impartial.
Yes,
Come
sir.
in as a
Yeah.
neutral, clear mind and make a decision based on what's presented to you.
Yes, sir.
If you can't separate yourself from a history of living on Smith Road, then you can recuse yourself, ask to be recused, and we would have an alternate member sit in your place.
Yeah, the unfortunate, the worst case we have in a state court right now, which precedent of kind of the example I've laid out, there was a case in a major city where a hotel was being proposed to be built, and the board members said on the record, I know that area, it can't take another hotel, it's too dense, it's dangerous. And the court said, I know he has knowledge, but you can't base it off that alone. You need to have someone here that can say, you can even ask the applicant, hey, I've lived there, what are your thoughts on this? And that way it's evidence now based on testimony. It's not just your statement on the record. You have some supporting evidence from someone else too. And is that any further questions on that, sir?
Yeah.
Okay, perfect.
Thank you.
All right, so we're going to move to the next slide on one of the, okay, so we have who can participate. Variances. All right. Variances. Variances are some of the tougher, decision you all have to make. So, because you're dealing with an applicant that believes an injustice has happened to them, and you have to make a ruling based on the evidence whether or not an injustice occurred, right? So, first and foremost, the applicant has the burden to prove every one of those elements. An unnecessary hardship would result if they were required to comply with the ordinance as written, that the condition of the land is peculiar to that piece of property. That specific property is different from other properties in the area that might be suffering the same harm. And then third, it can't be self-created. The most common question I get about this element is, let's say you move to Smith Road from out of town, and you know Smith Road can't be built based on a setback requirement, but you still move there. Unfortunately, as a board, it's not appropriate to say, well, sir, didn't you buy this house 2 months ago? Yes, I did. And sir, didn't you know that the setback requirements were this when you bought it? I did. That's not a self-created hardship. Our courts have said that just because you move somewhere knowing of a problem does not preclude a variance. But they have to show that, let's say, John Smith gets site plan approval to build a home, a 2-story home. And as he's building that home, oh no, he doesn't comply with the setbacks. And now he says, I want a variance. Well, then you have an issue there. John, you built the home. You built too close. You created that issue. You got approved for something else. You just chose to build otherwise. That's an example of a self-created hardship. And then the requested variance is consistent with the intent of the ordinance and is in harmony. It's usually a legal question. Usually where I, guide boards in that regard is, are we building something that is so far outside the realm of the general area? Or how are we going, is this person asking for something crazy? That's usually where that element comes into play. It's not as slight, yes, sir.
Okay, I was just gonna give an example. One of my town clients sits as the Board of Adjustment, and they had a variance application come up where neighborhood on one side of town was built in the 50s, single-story brick ranch homes, every so far apart, consistently, 3 or 4 streets wide. And one of the homes had been subject to a fire a couple years ago, and the owners weren't to be found. I think it was heirs' property that, great-grandpa's old home, nobody cared about. So it had been an eyesore of the town, and a local investor bought it and says, I'll fix it up. So they go to fix it up. And turns out it had structural damage, so he says, well, we have to razz this thing, start over again. Well, we didn't have the zoning statute in 1950, whenever the house was built, about setbacks. How far can do you have to set your house back from the line between you and your neighbor? That's generally what a setback is. Well, according to the code that existed last year at the time, none of the houses in that neighborhood met the code because they were all technically too close to their neighbor's line. They don't meet those setback requirements, but they were sort of, let's just say, grandfathered in. Okay. Well, this gentleman that bought the home had this problem now of, well, I've got to knock this home down because it's burnt beyond repair. I just can't fix it, but I'm willing to rebuild in the same footprint where it was, same size, same footprint, no closer, no further away. But to do that, I need a variance because once he tears that house down, that grandfathering goes away, and he's going to be subject to what's on the books now. So I'm not going to say it's the right decision or the wrong decision, but the board looked at those last couple elements there about, what's the spirit of intent of it? Was this meant to regulate these houses built in 1950, or was it meant to start spacing them out further for new construction? When was the law in place? When was it adopted? Is this a public safety issue? What's the spirit of intent? And is substantial justice achieved? That could be a little tricky. The board granted him the variance. I'm not saying that's the correct outcome every time, but substantial justice says nobody was being harmed where these homes were located. We are replacing it in the same footprint, and the board felt we're going to get rid of an eyesore and have a brand new home for the community. So that's just an example of substantial justice the board felt would be achieved by doing that. So that's a kind of a reasonable example of what a variance is. You've got these bright line rules we're asking for some exception to them. So that's when you have to weigh these factors.
And probably our most famous case right now is a case where someone received site plan approval, they started building, and the survey was off. It got resurveyed, there was only about 100 feet difference between the setback regulation and where it was built. The municipality said, yeah, you're gonna have to tear your whole house down. Well, the court said that's a variance, justice would occur. Let's stay in that example. It would be expensive for him to have to tear his house down, right? Big financial burden. Courts have also said financial burdens alone are insufficient. Famous example, a case that I was involved in. I had a client, I represented the municipality. The individual wanted to advertise on their commercial lot. They were going to build a restaurant, and they wanted to build a sign that was 100 foot tall. Well, our ordinance said 25 feet. 100 foot tall is 100 foot tall. That's not the same thing. Their argument was, well, we're between two highways. Hey, we're peculiar property. You know, it would be great if people driving both sides could see us. Our position was, and our case is supported. You're just asking to make more money. You can still put a sign there. The ordinance isn't preventing you from building a sign. You just want one that will allow you to get more money. A financial hardship that you're losing here alone is not enough. You have to show some type of injustice here. Use variances are not allowed. So what is that? You're in a commercial development, and let's say you're in a residential neighborhood. There's commercial development across the street because it was grandfathered in. And that person across the street says, hey, I want to build a commercial development because obviously there's a store right, or not development, I want to build some type of commercial establishment. Look across the street. You know, that property who's grandfathered in, they're allowed to build a commercial development. Well, no, that's not the purpose. The purpose of a variance, of a variance is to encourage development. It's not to change the use of a property. It's not to rezone a property. That's not the purpose of a variance, even if an injustice would occur. All right, so we'll move on. Oh, quorums. So you all thankfully do not have this issue because you have to have 4 people here regardless. Variances have a supermajority requirement. It takes 4/5 of the board to approve a variance. So if 3 people vote yes, 2 vote no, the variance does not pass. You have to secure 4/5 votes. Now, here's what's peculiar about variances. It is 4/5 of the board. Well, let's say Mr. Chair is not here one night, so Vice Chair is filling in, and the rest of the board is here. Vice Chair is leading the meeting, and then the rest of the members are here. We have 4 members here that can vote. Well, let's say the alternates can't be here. We only have 4 people here. Statute says 4/5 of the board. Just because 5 people aren't here doesn't mean that you can have, let's say, 1 person says no out of our 4, 3 say yes, 3/4, hey, we got it. No, you need a majority. It's 4/5 of the board. The number doesn't change.
4 votes.
Yes, sir. That's a great way to put it in your case. Keeping it simple.
4 affirmative votes.
I appreciate that a lot, actually. And thankfully you all have alternates. You have 5. You don't have to deal with, some of our larger boards have 9 people on them. This is perfect number, perfect setup.
Lawyers don't do math in public. So
We do not.
We're like 5 and 4 is really easy.
My first ever meeting on a Board of Adjustment as board counsel was researching this very issue. They said, we have 4/5. We have 5 people, 4 out of 5. That wins, right? I said, no, you have 7 members on your board. We cannot do that. That's not going to work. None of you are excused. So we have to have as many as possible. So 4 votes to pass a variance. If you don't get 4, it's denied. That's just the simplest way to remember it. That's how it is. All right, so special use permits, you all don't hear those, so we'll go through these. Administrative appeals. So we've already gone over this a little bit. Let's go to our notice of violation example. The town first has the burden to show you all through evidence that the violation occurred. So if someone gets cited, let's say there's an ordinance that prevents you from, you didn't mow your grass for 2 weeks. I'm just thinking of a crazy, doesn't exist. You didn't mow your grass for 2 weeks. And, you know, code inspector goes out week 1. He says the grass hasn't been mowed. I measured it. It's still at this length. Comes out week 2. It's still this length. It hasn't been mowed. They file a notice of violation, landowner appeals. We're going to do two examples. First example, code enforcement officer shows up, he testifies, he said, yep, I went out there, I measured week 1, measured week 2, hadn't been mowed, still 2 inches. Then that's evidence, right? We showed you evidence that the violation occurred. Different issue. Let's say town staff provides their staff report, we have this notice of violation, these are the allegations. Code enforcement officer gets sick, can't show up, no evidence is presented. What do we have here? We don't have any evidence. So in that case, the town didn't meet their burden. All right? Now, let's say there's a conflict. There's two different sides of the story here. There's a more complicated ordinance. Well, we'll stick with my grass mowing ordinance. Let's say there's two sides. Town says, I went out there every week. It was not mowed. I measured it. It's the same length. They violated it. So then town's giving you evidence to say, okay, violation. Well, let's say property owner gets an attorney or just shows up himself and says, hey, I'm going to be honest with you. I cut my grass. His measurements are wrong. Here's my measurements. I went out there. I mowed it this day. I mowed it that day. Well, now you have an evidentiary dispute. So you all, as a board, what do we have here? We have substantial evidence saying that there is a violation. You can determine whether or not there's substantial evidence to say the violation didn't occur. That's where you all come in. You all are the deciders of what we call the deciders of fact. You say what the facts are based on the evidence you get presented. All right? And then you say what the evidence is too, based on the objections you rule upon. So you resolve that dispute. But here's the caveat. It has to be supported by substantial, competent evidence. So again, let's say the issue is speeding. It's a speeding ordinance. Guy shows up and we have our officer here. He testifies, hey, I did the radar, 25 miles an hour. That's standard. Some towns have it. He went 30. I used my radar. I was there. It happened. Okay. Well, landowner shows up, said, I was driving. I went 15. I didn't go 30. That didn't happen. I could tell you this right now. And, well, sir, were you looking at your speedometer? No, I just know. I was driving. Well, you know what? We agree with Mr. Landowner. You know what? He wasn't going 30. Notice of violation denied. We really don't have any evidence to support that decision. I mean, you could choose to believe the landowner. Well, maybe that's a bad example because speeding at times you can. Anyways, it has to be supported by evidence is what I'm getting at. If there's the town proves its case and says, yep, there's a violation here, and the landowner doesn't show up, he just says, hey, I had a rough day, guys. I was speeding. Sorry. You know, please don't find me in violation. And the board rules against the town. Well, he didn't rule on it based on any evidence. So it has to be supported by substantial, competent, material evidence. Your decision. All right?
Don't recommend speeding.
Yeah, don't recommend that at all. I don't know if we have a speeding ordinance. I just wanted to make sure I covered something. Trying to go outside the realm of what we have. Okay. There was one on the bottom here, manufactured home. I believe that's transitioned over to the Board of Commissioners. I believe those hear those now. Am I correct on that, Mr. Plan Director? Perfect. So that one is, you can disregard that one. I was looking at the Muni Code ordinance and I misinterpreted that, so that's on me. The Planning Director interpretation, that's one of your more common ones. Okay, those are the interesting ones, because now here we are, non-lawyers sitting on a board asking to make a determination of what a legal ordinance says. Those are the tougher ones because you have to look at the language of the text. You have to make a determination. In North Carolina, we have a law that is, if it's ambiguous and it can be reasonable to two interpretations, it has to favor the landowner. That's our job. As the lawyers working for the towns, we have to write our ordinances in a way that are clear. And we'll help you more with that if you have questions during those hearings. Those are the tougher ones. You're not going to be an expert about it your first night. I've had far too many of those, and I'm currently fighting one at the Court of Appeals, so those are the fun ones, the interpretation cases. Are there any questions about administrative decisions? We've covered a lot. Any questions at all? Any thoughts? Yes, sir. I saw your hand moving.
Oh, sure. And to kind of tie things together, so, different types of matters are going to be before you. So that's what we've been chatting about. So the same standing requirements that we talked about
Yes.
for variance are going to apply to administrative appeals. Well,
Yep.
standing is nothing more than who has the legal right to to say something about this case. Well, obviously the parties, so the town issued a violation for not cutting the grass. The person receiving the violation has standing. That's pretty straightforward. I don't know that anybody else would have standing.
Especially the speeding one. I mean, who else is
Yeah,
coming
that's
into court
right.
saying you got speeding
I'm
there?
not gonna help anybody with speeding.
Yeah, no.
But for some of these variance requests, standing gets a little broader, like we talked about. Read administrative appeals, and certainly interpretations others might have standing. Most of your basic, what I call your basic, knock on wood here, basic, trash in the yard, you didn't clean out your trash, things of that nature. I don't think there's gonna be much challenge on standing who deserves to be here. But those same, applications, apply, the same thought processes apply there. And according to your UDO, the staff would issue a notice of violation, for not cutting grass or cleaning out the trash or whatever it may be. They've got 30 days from receiving that notice to file an appeal to this board. So that goes to staff, who will put that on the agenda for the next meeting and get those documents to you to review.
And I want to cover something that I probably should have addressed earlier. So when you all hear all the evidence, after you've heard the evidence, you're going to be asked to deliberate. It's tempting when you're new on a board to, huddle together, okay, let's talk about it. Everything you say in deliberations has to be into the microphones, has to be addressed to each other, because what it looks like on appeal, let's say that landowner in the cutting grass example, didn't like the ruling you all gave him. And he said, I want to appeal this. Every appeal I've ever done, and I think it's practice. Every appeal, there's a transcript that's made. And everything we say is labeled on that transcript, so it's important to speak into the mic, speak clear, that way it's on the record. And so that has to be done during deliberations. And then going back to who can participate, it's tempting when you have some of these more controversial cases to want public input. You got to be careful. You got to make sure they have standing. It's tempting, it's hard, it's not comfortable, because these are people in your community that you live next to in some cases, that you see at the supermarket. It's not comfortable. But unfortunately, it protects you in the long run, because what you can't have is a situation where the whole community provides evidence. But unfortunately, they live 5 miles away and don't even know where this property is located. They just don't like the fact that Johnny doesn't cut his grass. That's it. So you can't have a decision based off that. That's not competent evidence. The court would strike all of it, and then you're left with, okay, what did they consider that was competent? We don't have anything.
Right. And that's, if a decision of yours gets appealed to the court, all the court can look at is the record.
Yep.
The transcript of what was said. I mean, just like a court reporter in court,
Doesn't take new evidence.
that's the transcript. It doesn't review anything new. So the court has to decide, and the parties have to decide, or have to argue what's in the record. So documents handed in, staff reports, testimony. And so whether it's a procedural issue that they're appealing about, going back to opinion testimony, the board allowed Johnny down the street to say, well, if y'all build this, it's going to flood my property. And you say, daggone Johnny, you're right, denied. That's going to be a procedural problem. But if it's supported, and the court can look in the record and say, okay, well, they heard from X, Y, and Z, and the UDO says 1, 2, and 3, they apply them together, I think the decision was within the intent and the letter of the law, the UDO, the zoning code, and there's evidence to back up the board's decision. So keep that in mind, and that's another reason why, if you deliberate, it's got to be on the record. There's no closed session, private deliberations. Because of that, again, it goes back to, this is a quasi-judicial proceeding. There are certain due process rights that attach to these folks, these litigants, in front of you. And to tie it into about opinion evidence, it's no different really than a civil case in court or a criminal case in court. My background is not science. And I married somebody with an accounting degree, so I didn't have to take calculus and all those accounting in life. I let her do all that. So I'm not qualified to testify as a forensic accountant in court. If I have been arrested for embezzlement because somebody says I was embezzling money, to put me away, my due process requires that the person testifying saying, yes, and here's the evidence, look at these accounting ledgers. They need to be an expert and deemed expert. Just like, you think all the Hollywood trials, OJ and all these other famous trials, blood evidence, only experts can give opinions, okay? So that's the basic way to think about it. You can come in through experts. So the neighbor might have standing to come and argue, and there may be some gray areas there. But somebody 5 miles down the road that just doesn't want any change in town come in and say, well, if you do this, you're going to increase traffic by this amount and all these sort of things. They are not qualified and admitted to give evidence about traffic patterns and traffic safety and those sort of things. So generally speaking, opinions must come through experts, and that's really no different than civil court or criminal court. That's just the basis way to think of it. But again, it goes back to being a quasi-judicial. It's got to be based on the evidence and the record.
I have a
Yes, sir.
procedurally, it's a little out of turn. As it relates to our role and how these things operate, parties come in, whoever has the burden of proof goes first.
Yes, sir.
They offer an opening statement.
Yep.
Typically speaking. At that time, does the other party get an opportunity to do the opening statement?
I've wrestled with that procedurally in every role I've worked on with the Board of Adjustment. That's because I've done it different ways. I've done it where the attorney may come in and say, I've heard what the town has to say. I would like to give an opening statement. I've also had people come in and say, wait a minute, nope, I would like to speak and give my opening when it's my turn to give evidence. My advice on that, offer it to the other side. And some may not even want to give openings. I've had towns that don't want to do it. They said, I'm going to call my first witness. So my advice would be open to it, how you're thinking about it, opening then opening, but.
It's up to them.
Yes, sir. Yes, sir.
So it's like something to the effect of, you have the option of giving an opening, would you like to take that now?
Yes, sir. Because some boards don't even do openings at all. My practice, because I've had the situations where when I first started, I didn't. And then I had attorneys would come and say, hey, where do I fit in here? I want to give my opening. And so I always try to start with that. But it's not necessary if they don't want to.
All right, so just bear with me here.
No, please.
I mean, I apologize for taking your time, but
Nope.
the party moving with the burden of proof calls their first witness. They're on direct. They're asking all the questions. Somebody argues, objection leading, and that's something that we can rule on, right?
Oh, thank you for asking that. All right, I'm an evidence nerd, so I shouldn't admit that on public record. So under the statutes, you're not bound by the rules of evidence. You might have been a lawyer. Under the statutes, you're not lawyers. You're lay people. So the statutes give us flexibility to say, it happens. Not all of us are experts here in the legal field. You're not bound by the rules of evidence. However, there is a standard. One, if an objection's made, then you have the ability to, one, apply the rules. That's where your knowledge is, and you want to apply it strictly. Or you can say, this is a quasi-judicial hearing. What they're testifying to is competent. Competence is the only buzzword where you have to make a ruling, and it has to be in line with where the law is, right? But if someone's leading, I've seen attorneys do it both ways. My practice is, if we're dealing with lay people, and there's an attorney on the other side that's just objection leading, counsel, this is a quasi-judicial decision, the rules of evidence, so long as due process is followed. And the big buzzword for the statute is, for due process, does the other side have an opportunity to cross-examine that person on that issue? Let's say someone walks in here and says, you know what, I heard Steve say he's going to build a 500-floor building. I know that's a crazy thing to say out loud. Well, objection, hearsay. Well, okay. Yeah, that is hearsay. Let's say you were like, you know what, wait a minute. Let's see where this goes. I want to see where in the world they received this knowledge that Steve said he's going to build a 500-foot building. Well, that person has the opportunity to cross-examine them on that very topic. So my recommendation, if you want to go by the book, I'll always be pleased with you. I'll always be happy with if the rules of evidence are followed. But if you sit back and say, I'm not really going to enforce leading questions here because we're not this guy didn't go to law school. Let's let him have his way here and question them. That's fine. As long as due process is preserved, in other words, they had an opportunity to cross-examine, we're good here. But you do run into issues where, same scenario. I heard Steve say he wants to build a 500-foot building. Well, the board hears that and says, well, then I don't want to approve this project. Well, Steve never showed up, Steve never said that. It goes to competency. Was it reasonable for you to rely upon that information? It was solely hearsay. Not really. Steve never showed up and told you that. You just heard someone say that he said that. So even if the evidence got brought in, there's a chance the court could reverse it and say that wasn't competent. Because why in the world would you believe something someone said is the only reason you denied the project? So yes, the rules of evidence are flexible, and I can get you a statute on point with it, because I found that to be helpful with some of my other boards. I will not be mad if you go by them to the T, though. That's my, any further questions about that?
I do.
I have another mechanical
Yes, sir.
question. When we get an application from you, John, it's for a violation of an ordinance usually. And will you provide a copy of that, the appropriate section of the ordinance?
Yes,
Okay, with us, so we know what,
absolutely. Yep.
yeah, okay, thank you.
I'll put all the information that's needed in
Yeah.
there, so you guys can.
Okay, thank you.
I have a question.
sir.
Well, you mentioned that there's no private conversation up here
Yes, sir.
during this hearing. So when we get the notice of hearing, let's say there's some, the ordinance comes in and we know what we're going to be hearing. Two of us run into each other down at the food line, and while we're picking out our barbecue sauce, we have a conversation about it. Any problem with that? It's private conversation. Any problem with that?
My best advice in that situation, just say it on the record. I saw Scott at the supermarket. We talked about it. We didn't go in depth. We just said, we have an ordinance hearing. It's on Tuesday. It's on this topic. I think I can be impartial. Applicant, what do you think? And most of the time, the applicant will either say, they'll be difficult, and they'll say, well, I want a continuance, or I want them recused. Well, they've said they can be impartial. They just said that they being Scott and Mark, just talked to the supermarket and said, we have a hearing next week. They didn't say,
That no private conversation applies to in and outside of this room.
yes, sir.
Okay.
Just like with judges on the bench, I can't talk to them at the supermarket either, unfortunately. Something funny.
The one easy practice is, other than saying, hey, Mark and Mark, all the Marks, looks like we got a doozy next week at the meeting. I'll see you then.
Yeah, that's not ex parte.
No problem, because you're not really talking about, well, did you see Johnny Smith's application is up here, and you remember X, Y, and Z?
Wants to build a 500-foot tall building.
Yeah. Well,
Yeah.
Years ago, my grandfather tried to do the same thing, and the town said no, so here's pay about it.
Yep.
No, that's, when you start talking about the merits or the facts involving it, that's when we have issues.
Okay.
And to me, that sometimes can be low-hanging fruit for a party that's unhappy to say, that's my basis for appeal. I didn't get due process. They were talking about this outside.
And that's a good point. So the court doesn't take in new evidence, but there is an exception in the law. There's a doubt as to whether a due process was followed. Then you have an opportunity to take in new evidence. For example, if you ran into, let's say Scott and Mark were talking at the supermarket. They were talking about John Smith's application. Yeah, man, I drove by his house. He never cuts his grass. It's 5 feet in the air. Can't even see his home. And then Sally over here hears it. She goes, wait a minute. I hear this. And for some reason, John's attorneys run into Sally. Hey, John, I just want you to know, I heard Scott and Mark talking about your 5-foot, lawn outside. You haven't cut it. Hey, don't you have a hearing on that next week? Yes, I do. You all denied the application. Well, now the lawyer for John submits an affidavit on appeal and says, hey, Sally Sue here says she overheard Mark and Scott talking at the supermarket. Court's going to consider that and say, oh, wow, they really didn't have due process here. Send it back. And usually the remedy is you get to hear it again. And that's usually what I tell my boards. Let's make sure due process is, because one of the remedies is you got to hear from the same people again. Let's get it right the first time.
Lacks in inefficiency.
Yes. Any more questions about that? Yes, sir. Mr. Chair.
I have another, just trying to conceptualize what a hearing would look like.
Yeah.
So direct goes on, they finish their direct, maybe there'll be some objections that are ruled upon. And the other side gets the cross-examination.
Yes, sir.
And then redirects are allowed?
Sure, if you say so. And that's it, I always recommend to do it. hey, you got any further questions?
Or recross or whatever.
And it's one of those situations where you're sitting back as the chair saying, they've gone back and forth 3 times. I don't want to hear this again. Any further questions? Anybody? All right, cool. And I know, but again, that kind of steps out of our structure of direct, cross, recross, redirect. It kind of steps you out of that a little bit, but because your goal is like talking about the due process aspect, making sure that's maximized. It gets really complicated where you have a case. I'm going to add another element to your procedure because I like where this is going. Let's say you have someone who has a application for a new neighborhood and a couple of the residents establish standing. Well, now it's not direct cross 1, cross 2, or excuse me, it's not direct cross, it's direct cross. Anybody with standing want to cross-examine. So you have multiple lawyers and or parties cross-examining. If they establish standing, they're entitled to participate. I had one hearing where we had 3 lawyers cross-examining 1 witness, and it was a lot, but they had their time. And then you have your redirects, like you're going through, essentially, sorry, does everyone know kind of what that procedurally looks like, direct, cross, recross? Does everyone know what that means? So direct examination, the person who called the witness is asking their witness questions. Cross-examination, that's where the people who are opposing that party or is adverse to that witness gets to ask questions. Redirect, person who called the witness essentially tries to clean up everything that their witness said in cross-examination. Recross, person who's adverse gets to ask them additional questions to try to get some more evidence on in that case. Yes, sir.
Hypothetically,
Please.
there's 4 people that allege to have standing they want to cross-examine.
Did you find them to have standing is the point.
When does that happen?
All right, that's a great point. So you have to establish standing to participate. John can't walk into the town hall and say, hey, I have standing. I'm here. I'm participating. Here's my lawyer.
Yeah.
You can't do that.
Can't come on 2 witnesses deep.
So
and
the
say,
way I ask my boards to do that is when they first speak, sir, please provide your standing, not your standing, please tell us a little bit why you believe you have standing to participate. Well, I live next door. I think my property values are going to go down because I'm right next door. I want to participate. Okay, well, let's say Steve runs in with his lawyer. Because the lawyers are going to try to jump in. They got standing or not, they're going to try to be there. So Steve comes in with his lawyer and he says, hey, here's my lawyer. I live 5 miles down the road. I think my property values are going to go down. I think that, this is hazardous to me. Wait a minute, Steve. This is 5 miles down the road. What is your property values going to go down? Well, I brought a lawyer. Well, hey, you don't have standing. Sorry, Mr. Lawyer. Thanks for making the drive. But that's kind of where it is from the beginning, right?
Who rules on whether or not they have standing?
You do.
I don't know.
You do, and it's appealable to the board.
Is it something that we could rule on as a board, or is it just me?
Starts with you. Starts with you.
They can appeal that to the board.
Okay, so it's
that's
that whole
the board.
thing.
Yes, sir.
All right.
Yes, sir. And that's the one exception to, okay, let's say, back to our John example. John's upset about, y'all denied, no, let's go back. Steve ran in with his lawyer, y'all said he didn't have, the board said he didn't have standing. Well, now it gets appealed to Superior Court. John's appealed it, town's there, parties, perfect. Well, Steve's mad that he didn't get to participate. Steve can try to establish standing again. He can try to intervene. But on the other side, and this doesn't really apply to you all, let's say you find someone has standing. Well, it gets appealed. Let's say y'all say Steve does have standing. Well, it gets appealed to Superior Court. The other side can attack whether or not he had standing to begin with. So even if we get it wrong, there's a second bite at the apple. My advice, get it right the first time, because it makes your night a lot easier. If you don't believe someone has standing and they don't establish it, that's less lawyers you have or you have less people participating.
But if Eric's put on the spot like that, he can just look over at you and say,
What do you think?
what do you think?
And I'll say, hey, at this point, I think that I've heard testimony from Steve, and Steve said, I live 5 miles down the road. Mr. Chair, I don't think that's in the immediate vicinity. He doesn't really talk about how he would have special damages. At this point, my recommendation would be to conclude, I don't think he's established standing. Still your call, though. Okay. Always want to leave it in your court. Because you could say, you know what, Clay, or Mr. Davis, I think that, I think he did establish standing. I disagree with your opinion. Totally fine.
And as a matter of procedure and practice, usually when you reach an agenda item that's, variance or something, and the parties come up, I think that's when you would
Yes.
address it at the beginning is, okay, who was here for item number 7, this variance application?
Yep.
Town staff would speak up, the applicant and or their attorney would speak up, and you can usually open the floor to say, is anybody else who would like to speak on the matter, wishes to speak on this matter? Obviously those two parties are going to have standing. Anybody else comes forward, okay, tell me your name, who are you,
Where do you live?
where do you live,
Yep.
all that kind of stuff to kind of go through that quick checklist of what gives them standing here. And then you can make that determination before you start putting on witnesses and evidence.
They have to be sworn in?
Yes, sir. Thank you. You
Yes,
read my
sir.
mind. You'll swear them in at the beginning. And I would just invite anyone who is going to be providing testimony, please come forward. You need to be sworn in.
Who swears in?
That's a good point, because the clerk usually does it. I would advise, honestly, I think you would give, no, because you would be testifying.
Maybe the secretary to the board.
Yeah, secretary of the board says the clerk, yeah, good point.
Yeah, so,
We can check the procedure on that, that's a good point.
Yeah.
Who can administer that? It has to be, yeah.
yeah, last year it happened to be the town clerk too, so that was easy.
Because I think technically the chair could also swear, can't they?
The chair can swear.
Yeah, because they're presiding, yeah, so you could, chair could technically do it. I know,
add
sorry you
that-
got,
add
sorry you
that
got
also to
elected.
the list there.
You shouldn't have led with I was a judge.
Eric, we appreciate you, brother.
Andy had a question for us.
Yes, sir, someone else had a
Okay,
question.
I have a question for you. When, obviously, when you're talking about somebody being 5 miles away from the incident,
Yes, sir.
reasonable that they're not involved in this.
Yes, sir.
But in the environment that we work in here, you live on X street, and you're gonna do something across the street from me. Obviously, I have standing because you're right across the street.
Yes,
Your
sir.
two neighbors, how far does that go within reason?
So, there's a famous case out of Raleigh where someone was able to establish standing, I think like 2 miles away, because they could show stormwater impacts. The business was gonna be built, and then it was just gonna flood this amount of homes, and the ditches there couldn't handle it. So then they had evidence to show that. Well, they established standing, even though they were 2 miles away, they were showing this development was gonna have a downstream effect that was gonna flood my property. So it really depends on why they're 5 miles away and saying they have standing.
If it's a case of, my deck's 20 years old and I need to demolish it and rebuild it, well, the code they passed 2 years ago, now if I rebuild it as is, now I'm in violation of some setbacks or something. I live 5 miles away, I want to speak on that. That's not standing.
I don't want that type of deck in my
That's a
neighborhood.
waste of
Yeah,
time.
you can't have that.
That's a waste of time. And they may say, well, I got it done 5 years ago, or they denied me 5 years ago, and I want to be heard. They really don't have standing living 5 miles away on an issue like that.
That's another instance. You may have people that will say, well, I applied for a variance 4 years ago, and y'all denied it. I want to make sure this person gets denied too, because I want to make sure it's the
Well,
same.
your predecessors denied it.
Well, that's not standing, sir.
Not standing.
Do you have any more on that? Any more questions for,
I guess it varies from case to case.
it definitely is, sir.
But, yeah, I mean, when you talk about 5 miles away, unless they can actually prove it, but I mean, we're gonna deal with, I live on X Street, and the neighbors, how far away is reasonable, and then it's a judgmental call on our part.
Yes,
on the
sir.
board's part.
Whether or not they'll be affected, because in like when you have those cluster communities, some communities are very cluster developed, they were developing clusters, so then you have this situation where, well, that might actually affect my property value, yeah, I'm very in close proximity. I'm not adjacent, but there's an alley between me and that house, and maybe it would affect the property value. That's something that you all can consider.
And to state the obvious, we're on an island.
Yes.
We're not annexing new land
And you're,
anytime soon or
you're
anything like
a
that. So
straight right of way that we all share, or
these
state
are
road.
going to be,
Yeah.
issues that are going to come up. How close, how far is far enough away in a smaller city?
Yep.
Those are very good questions to address that.
Anything further on, oh, yes, sir.
You good?
Okay, I'm
Good, cool. Yes, sir, Mr. Chair.
Sorry to monopolize, but
Please.
when the litigants are done, is the board allowed to ask questions of any of the witnesses?
Yes, sir. I recommend you do that. I recommend you go applicant direct, cross-examination, after the parties get done with their questioning. Does anyone from the board have questions? That's when you all would chime in, and you all would say, Mr. Chair, my best way to recommend it. Does anyone from the board have questions? You can either go in order, or you can just say, does anyone from the board have questions? And go from there. However you want to do it. You want to make it structured, I've seen both ways. Yes, sir.
Now, only those five can question. We just have to sit here, correct?
That is the
We
tough
can't-
part. Yes, sir. Yes, sir.
Pass notes. Yep.
Yeah, Mark. Text me, bro.
I don't know about that text, and I didn't see that note, if anyone asks.
We don't need that.
If anyone asks.
And to piggyback on some of the other statements as well, about due process and, you know, expert and who gets standing to hear, it is a little bit of a balancing act because, it's quasi judicial, so, you know, there is case law that says rules of civil procedure and evidence don't apply strictly. But then there's also required statutory law that says, you know, experts, you know, opinions, they're experts in certain topics and these things. And to the example of, you know, maybe one side's here without an attorney and an attorney's on the other side just kind of badgering them, you know, hearsay, leading, objection, just trying to shut them down. Well, are they going to feel as if they're getting due process, or are they going to get due process because they don't know the rules of evidence about leading questions and these sorts of things? Or is due process going to be better served by saying, I hear them, I hear your objections, but let's let them speak and try to get some questions asked, you know, that sort of thing. So that's where some of that balance may be struck on some of these evidentiary issues. I think if you, and every case is different, every facts are different, every judge hearing an appeal is going to be different. But with due process in mind, you know, especially with pro se folks without an attorney, it's nice to clear the judicial due process hurdles if they got a chance to speak. If you had a lawyer on the other side that was shutting them down because technically they violated some hearsay objections and different stuff or whatever, and in a court of law, absolutely, we could shut them down and they could really never get a question out. But if that happens here, I think the option for them to say, is that really due process? I didn't even get a chance to speak. I think that would be maybe an inroad for a judge to say, y'all do that again.
I've seen a board overturn, I've seen a court overturn a board's decision for that reason. They said, you know, the person showed up and they didn't have a chance to present evidence because the lawyer on the other side just kept objecting. I was not that lawyer, but my advice is, the lawyer is not there. Would that person be able to present their evidence? Because lawyers aren't mandatory in quasi-judicial unless they have a representative, right? So, okay, that's another issue we'll talk about, but we'll get to that. Lawyers aren't necessary. Lay people can show up, non-lawyers could show up and give their case. And that should, I always like to keep that in mind when I'm advising boards, saying, hey, this person, like Tim said, they're objecting to everything. I don't care if they're leading. I just want them to have a conversation with me as a board member. I want to hear their evidence. And if it gets too far off, chair can step in, right? If they're talking about, if Steve's talking about this other person's grass across the street saying it's 10 feet tall, why aren't y'all punishing him? Well, Steve, we're here about you tonight. Let's stick within the purview here. I, as the lawyer on the other side, might not be objecting, because I also have a rule, if boards are going to hear on irrelevant information, I'm not going to take your time up with objecting. I'm going to object once and let you decide what you want to hear. Some lawyers might do that too. So as the chair, you have that option to say, you know, hey, we're kind of out of order here. So keep that in mind as well. Oh yeah, I gave a caveat earlier about lawyers. This happens a lot. John owns a business. John has a friend helping him design his plans for the business. John sends his friend who's designing the plans to apply for a variance. He comes up there and he calls witnesses. He starts providing testimony. You can testify, but you can't have non-lawyers serving as lawyers. In other words, if you have an engineer that shows up and he starts calling other people, other witnesses that show up, that's not allowed. That's the practice. Quasi-judicial decisions are the practice of law. Rezonings are different. You will see that at city council, or excuse me, town council. You will see non-lawyers. That's legislative. That's where they're not taking, they're taking in input, but all you need as a council is a plausible basis to make your legislative decision. You're not making it off of an evidentiary standard like you all are. Y'all are taking in evidence. So a non-lawyer can't come and present evidence and present witnesses unless they're the applicant. I can represent myself in court. I can represent myself in front of a quasi-judicial board. What I can't do is have Steve, my engineer, come and lead my whole case. And that gets tough. The rule on that is, I, as your attorney, have to inform you of that. I have to tell you, at this time, there's an individual who is not a lawyer, you're not a lawyer, sir or ma'am, nope, okay. Technically, he cannot represent this person. I have to inform you of that ethically. Then Mr. Chair, you all make the call. You make the call as to whether you're not going to allow them to proceed. The rule is, I can't help facilitate the unlawful practice of law. If you all say, you know what, we're going to let them proceed, and I've done my ethical duty, I don't recommend it, but that's all the opinion tells me to do. So, no non-lawyers come and represent other people. It's my recommendation. Businesses get tricky.
I was gonna say, you wanna address?
Yep.
Corporations and LLCs?
Corporations get tricky because you have the shareholder that comes. Cases are unclear about that. You can't be a non-lawyer in court and represent a business in district court or superior court. Can't do it.
Correct.
But then you fall into the argument of, well, I'm the property owner. I'm the manager of Steve Smith LLC. I'm Steve Smith. That's me. You know, should I be able to provide my evidence? Still looking into that issue. I haven't had it come up yet, but I still don't have a definitive answer. My knee-jerk reaction is to tell you no, because if it's not good for an individual to be represented by someone else, you look at corporations as people. So we'll probably have that conversation in the future if it ever comes up. I don't have a direct answer.
And the reason why, at least in district and superior courts, a corporation or LLC cannot appear but through a lawyer is because the court doesn't know what the bylaws are of this company. They don't know, I'm John Smith, here's my business card, I'm the president of John Smith Incorporated. Well, that's great, but, you know, if you're not a majority shareholder, can you make decisions on behalf of this company? Your bylaws say you need this many votes or shares voted to make that decision. So the reason why in civil and criminal courts, not criminal, but more civil courts, they require an attorney is because the attorney's job is to sort all that out and then take that company's position to court. So the danger here would be, I'm John Smith, I'm the president of John Smith Incorporated, I'm here for this application. And we proceed, and what we didn't know was that his soon-to-be ex-wife is vice president, and under some other divorce decree, she's going to get 80% of the business. Oops.
You didn't have the power to make that call.
So these are, you know, tripwires we try to avoid, and that's what we're here for. Help avoid those. That might be a landmine, but yeah, absolutely.
Do we have any more questions? I was just going to wrap it up with the vested rights section and then answer any overall questions we had. Anybody have any questions on the, okay, perfect. So vested rights, there's two types of vested rights. Vested rights is if you're going to encounter them with some of your older developments or when there's a change in the zoning code that affects a property owner. So if you expand a lot of money after you've had some type of governmental approval, which is, case law tells us, allows you to build. That's how I interpret it. Some people disagree with me, but that's my interpretation, is are you allowed to use your property a certain way? Do you have that approval? Okay. So let's start there. Let's say John was approved to develop his lots, a residential lot in the 2000s, 2008, decline in the economy, wasn't able to build it completely, but he started building. He had a building permit. He started building it up, building it up, building up. He finished it in 2015. Well, code enforcement comes by and says, wait a minute, John, that doesn't comply with the setbacks from 2015. Wait a minute. John expended substantial expenditures towards the completion of his project. He spent a lot of money to build it. He had good faith reliance on governmental approval. He relied on his building permit. He relied on his site plan. He relied on his plat. And then he spent the money. And an injustice would happen here. That's the last one. The owner would be harmed without that vested right. John's going to have to tear down his house. That's an injustice. So that's an example of a vested right. That's one of our more complicated administrative decisions. We will certainly cover that more as we get closer, if we ever have one of those. Statutory vested right, that's when you can submit a plan to a zoning administrator and say, I had all these prior approvals, here's my site plan based on those prior approvals, I had a building permit, please accept this as my vested right. So common law is more court-made, that's more evidentiary based. You have to present the evidence. Statutory, it's laid out. Did you have a building permit? Do you have a site plan? Can you present it to the zoning administrator? It gets approved. Here's the caveat. Statutory vested rights only last, I believe, 3 years, maybe 2. I always get them mixed up. It's 2 years,
I
perfect.
was holding down to.
Thank you so much. So 2 years. If you don't build within 2 years, vested rights go away, expire. That's the difference. Common law is why most people try to go for it, because common law, it's a reasonable time, it's the closest thing we can find to a time period. They vest as long as the permit's valid. And so you might see both, but you don't really need to worry about the expiration unless someone comes back to you and says, hey, the zoning administrator told me 2 years has already gone by, I'm expired. Hey, I have a vested right. Well, sir, the statute says what it says. You have 2 years. You didn't get an extension, so that's hopefully an easy case for you. That's really the only difference. But again, you'll have that laid out prior to, or during the hearing, probably during the staff report, have some background on it, Mr. Plan Director. Perfect. So you'll get that background more when you see one of those. But those are some of our more complicated ones. Is there any questions about anything you've heard tonight? Any questions about the process? Perfect. Thank you all for.
I have a
Yes, sir. Yes, sir.
a comment, though, first. Has anybody here seen an actual application form that John gets to, for a variance? I didn't think so. Basically, the application that the applicant has to fill out has 3 basic questions on it. And they are the same questions that, and they write out an answer and to those questions. And that is what we get in advance to look at. And those are the 3 criteria that we use to make a decision. So it's really pretty straightforward. It's a 2-page questionnaire, and, or maybe it's 3 now, I don't know, but and they fill it out most of the time handwritten, and John will provide that to us. But what it says, what those questions are these 3 questions that I made copies of, and this is verbatim, but I'll just read the 3 questions, and it's really kind of summing up what you said. But question 1, there are practical difficulties or unnecessary hardships in the way of carrying out the strict letter of the ordinance. That's criteria 1. The variance is in harmony with the general purpose and intent of the ordinance and preserves its spirit. That's 2. And the third one is the granting of the variance secures the public safety and welfare and does substantial justice. So when we make, to grant a variance, we should answer yes on all of those 3 things. Or they can say, they can meet 2 of them, and the third one they fall down on, and we should deny the variance. But the application form would be an interesting thing, John, to, I don't think any of the words have changed, the format's changed.
No, I'll send, it's available for download online, our website, but I'll send y'all a copy of it so you can see it.
It's a brief way of finding out what we're supposed to do and how we make decisions, you know.
Aren't we having this training now because there's an anticipated hearing coming up?
No,
No, okay.
no, we just wanted to give a training to you guys, just so you had the heads up. You can ask any questions you wanted to.
Well, this was extremely helpful for me, so thank you.
Yeah.
Thank you.
Yes.
And there will be questions
Okay, just take one.
that come up, whether it's procedural or anything else. You know, we were available, I think our emails are on there. I've got some business cards, please take some. There, you know, we are the board's attorney, this board's attorney. We don't represent the town or anybody else. So you guys lawyers, we're here to help you. So, you know, please reach out with questions as they come up. Tonight, you probably felt like you were drinking from the fire hose. A lot of information coming at you. It's hard to swallow all at one time. But that's That's what we're here for.
And thankfully, you don't see all of that at once, right? So you're not
Absolutely.
gonna see a vested right with the variance
Absolutely.
all in one night. Thankfully not.
Hopefully not.
Hopefully you don't see a vested right.
That's right. Oh, gosh, I think we've covered most of it tonight. As these questions come up, reach out to us. As any attorney-client, you know, there's no confidentiality between you. So if one of the Marks asks me a question, no problem, here's your answer, you know. And I talked to another Mark later, and I can't, you know, and they said, well, don't tell the other Mark I asked that question. Can't do it. No big deal, no big secret, but as between you guys, there's no, confidentiality. So what the board knows, the board knows.
Yeah, that's a good way to put it.
I assume they deliberate in open session? and
Yes, sir.
not in closed.
Correct, yes, sir.
Yes, sir.
It has to be an open session.
That's always the toughest part, is having everyone lean into the mic at first. Like I said, everyone's instinct is have conversations back and forth. You gotta lean in. Yes, I think that.
It's easier tonight when there's nobody leering at you. They
Yes.
comment about, you know, please rule for me. You know,
Oh, a room full of people, it's,
It could,
So
it can
different.
be intimidating at times.
100%.
And that's okay, you know, and that's okay. That's kind of why we wanted to get on board early. So, you know, kind of get this stuff under our hands so we can use it.
This was great.
Thank you,
Thank
thank you.
I appreciate you saying that. Thank you.
Absolutely.
All right. No further questions. That's all I have. You got anything else, Tim?
No,
Thank you all.
the lawyer to say he's done talking is really good, so we're good.
I don't get to do it all.
I think the only thing we need is a motion to adjourn.
Move to adjourn the meeting.
Second?
Vote. All in favor?
Aye.
Aye.
We are
There it is. Great job.